Welcome to the latest episode of Called to the Bar, International Law Over Drinks. I'm Imogen Saunders, Associate Professor at the Australian National University School of Law. Our topic today is triggered by three recent Australian cases. First, the news that Ben Roberts-Smith, an Australian former soldier, has been arrested for war crimes allegedly committed in Afghanistan. The second case relates to the so-called ISIS brides. Regular listeners may recall we talked about ISIS brides and children in conflict in episode 74, when the women were still in Syria. Shortly after that episode aired, some of the women returned to Australia, and two were subsequently arrested for crimes against humanity. Finally, we have recent news that the High Court of Australia will hear a climate case brought by MAC Energy Australia. All of these cases have one common thread: the importance of international law in our domestic courts. The underlying sources of the crimes that are being alleged are international law. Similarly, the underlying issues of climate change and climate law are heavily based in international treaties. Accordingly, in this episode, we are going to explore the use of international law by domestic courts. But I want to make it very clear that we will not be talking specifically about these current cases, but rather more generally about the importance of international law in domestic law today. I'm incredibly lucky to have two of the foremost experts in Australia on precisely this subject here with me today. Joining me is the Honourable Michael Kirby AC, who among many luminous positions has served as Justice of the High Court of Australia, President of the New South Wales Court of Appeals, and inaugural Chairman of the Australian Law Reform Commission. Michael has also undertaken significant work for the United Nations, including chairing the UN Commission of Inquiry into Human Rights Abuses in North Korea, and serving as the UN Special Representative for Human Rights in Cambodia. Michael is deeply respected, admired and beloved amongst academics, law students and the legal profession generally, and we are so honoured to have him on the podcast today. Joining me also is Christopher Ward SC, an internationally recognised leading barrister with a particular expertise in international law. Dr. Ward has chambers in Sydney and London, has appeared in all major international courts and tribunals, is Global Vice Chair of the International Law Association and an ambassador for the Capital Punishment Justice Project, working on death penalty litigation throughout the world. Chris's new book, International Law and the High Court of Australia, will shortly be released by Melrose Legal Publishers at The Hague. He is the ultimate expert on the topic we are discussing today. Michael, Chris, welcome, and thank you so much for agreeing to appear on the podcast. Before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. Let's start with our traditional first question. Michael and Chris, what's your drink today?
A cup of Assam tea. None of this flavoured or perfumed. Justice Gummo loves the perfume tea, but for me, it's truck driver's tea, Assam tea.
Lovely.
And thanks to being corrupted early by my grandfather, I'm a bit partial to a nice single malt, but because it's not yet lunchtime, let's stick with a nice cup of coffee from Timor-Leste, which I'm drinking now. I work pretty closely with Oxfam here and in the UK, and I strongly recommend their fair trade Timor coffee.
Oh, very nice. Well, I'm also having coffee. It's not, I don't know if it's fair trade, I'm embarrassed to say, but it is out of international law themed mug. So it's on topic for the podcast. So to kick us off, Michael, both on the bench and extracurricularly, you have written extensively on the use and incorporation of international law in Australian domestic law. Now, Australia is known as a dualist system when it comes to domestic and international law. Could you expand for our listeners what this means?
Well, the dualist system normally is taken as meaning that unless a local parliament, a municipal parliament with the constitutional power to do so, incorporates the principles of international law in a particular case, either as a statement of the common law or as a provision of a treaty which is binding on the country, or even a treaty that is not binding on the country. That is not permissible, that you have to have it incorporated by Parliament. And that was challenged when I went to a meeting of the judges of many of the Commonwealth countries, plus one non-Commonwealth judge Ruth Bader Ginsburg. And Ruth was there, and I was there, and not as judges of a final court, but as judges of a semi-final court. And we were there to add our light on it from the point of view of judicial officers dealing with cases which sometimes had a resonance to international law. And the question was, should we stick or do we stick to the dualist principle, or do we take account of the age we live in as a contextual matter and use international law for guidance in what the domestic law is?
Thank you so much, Michael. And we might return perhaps to questions around treaties later in the podcast. But before we get to that, Chris, you did your PhD on the exact topic of the podcast today, and indeed your upcoming book is exactly on point. What were your key takeaways from your thesis and now your book?
Goodness, the thesis was a long time ago. I wrote that in the late 1990s. Let me answer that then in two parts, a sort of then and now. So when I wrote the thesis in the 1990s, there were notable influences in domestic law from international tribunal decisions, including some decisions of the ICJ, but they were relatively sparse and ad hoc. And, for example, I remember noting with some surprise that there were decisions of the European Court of Human Rights being cited by Australian courts, but not regularly the views of the United Nations Human Rights Committee, which of course arise under a treaty to which Australia is actually a party, as opposed to the European Convention on Human Rights. And the doctrine of the margin of appreciation is one example of a European concept that filtered its way into our jurisprudence through that path. I was particularly interested back then in exploring the ways that various participants in the legal process were able to bring the work of international tribunals before courts, but also into the work of Parliament and parliamentary committees. And that process of dialogue, I think, continues today. So back then, references to international tribunal decisions were sporadic, but there were a few notable standouts. Of course, Michael made reference to the relevance of views of organs of the United Nations in his important early decision when he was president of the New South Wales Court of Appeal in Jago and the judges of the District Court of New South Wales. Justice Brennan in Gerhardy and Brown made express reference to the opinion of Judge Tanaka in the decision of the ICJ in Southwest Africa. And again, Justice Brennan in Mabo No. 2 spoke of the relevance of international law to domestic decisions. And again, Michael regularly made reference to the work of international tribunals, but also to international law generally, not so much as a foundational rule of Australian law because of the dualist restrictions, but as additional support for propositions of domestic law, making clear that the principles of statutory construction that were being considered could be guided by the work of international law and international tribunals. And so in that period, we had these sort of sporadic references to international law, but I think a normalisation of references to international law through the work of Michael and other members of domestic courts in Australia. More recently, that's changed, and I think partly because references to international law became normalised during that period. And so we now have, for example, in Montchilovic and the Queen in, I think, 2003, Chief Justice French noted that Australian courts could draw assistance from judgments of both international courts, but also foreign domestic courts, which were relevant to the interpretation of a statutory provision. In other cases relating to Australia's new or relatively recent slavery laws, there have been references made to decisions of the International Tribunal for the former Yugoslavia. And the High Court has, in the last 2 or 3 years, engaged in a number of decisions which really drive home its current understanding that international law and the decisions of international tribunals are directly relevant to statutory interpretation. And I might come back to that a little bit later. But for example, in Kingdom of Spain against Infrastructure Luxembourg, the High Court looked at the various statements of the International Court of Justice as to the existence of rules of customary international law about waiver of foreign state immunity and accepted the views of the International Court as being binding and consistent expressions of customary international law and statements of customary international law that were applicable before our courts. And so although the dualist tradition is fully maintained, we've certainly seen in the last, say, 10 years, much more regular references by superior courts to the work of international tribunals.
If Justice Dixon said that on his death there would be emblazoned on his heart Section 92 of the Constitution, I think it was Dixon who said it, and I think emblazoned on my heart will be the Bangalore Principles. The Bangalore Principles were the principles that were established by all these judges unanimously from Commonwealth countries, plus Justice Ruth Bader Ginsburg, and they were established unanimously by these judges. And I went home to Sydney from Bangalore, where the principles had been adopted, and I had a case concerning the right to an interpreter. And the High Court authority on that, I was at that stage in the Court of Appeal of New South Wales, the High Court had a principle about a right to interpreter. This is a matter of practice and procedure. It's a matter of discretion of the court, and that was about it. It was a very general principle that wasn't very much help in the particular case. And so I suddenly thought there was an explosion in my mind, and I thought of the Bangalore Principles. So we went outside. I was sitting with Justice Samuels, who was a very fine judge, and Justice Clark, another very fine judge. We went into my judicial chambers, and I took out the ICCPR, which Australia had ratified, and I said we should apply the principles of international law, or as an analogy and as a context-setting source of information. So we went back into court, because a lot of the stuff in the Court of Appeal has to be dealt with immediately, and the judges have to give their reasons immediately and just dictated, and the transcript is taken down, and that's it. And so I said at the end of it, and another reason, elaborating what the High Court said, is that if one looks at the international principles, which Australia has accepted for the purpose of ratification of the ICCPR, we should have regard to the provision relating to the right to an interpreter. And when I gave my reasons to that effect, Justice Samuels said, although that international treaty hasn't been brought into operation as such in Australia, it is a matter which Australia saw fit to endorse. And likewise, Justice Clark. And I was astonished that they both said that this was not heresy. This was something which we could do for the purpose of setting the context of the solution in Australia of a problem which called upon for consideration an international treaty. And that was what we did. And that, I thought, we have reached the Enlightenment. But subsequently, attempts in the High Court and attempts in other courts to invoke it have fallen foul of the dualist principle, and people say this is heresy. Justice McHugh actually declared that I was guilty of heresy in Al-Kateb against Godwin by invoking the international law principles, and that was about the right to indefinite detention. And so it's a slow-moving process, but it certainly appears that things are gathering momentum, even more momentum, in the cases that Imogen has mentioned at the beginning, and that Christopher has described and has in his wonderful book that is coming up, which has a splendid foreword by me.
Well, for which I'm very, very grateful. Thank you.
I think what's really interesting, perhaps for listeners to realise, is a strict application of the dualist principle means that any state, not just Australia, can be in a position where it takes on international obligations. Its domestic courts then don't take those international obligations into account, thereby its domestic law potentially breaches the international obligations. The state is held liable internationally because international law just views domestic law as a fact. Domestic law is never an excuse for a breach of international law. Yet domestically, a court might insist that the treaty, if it hasn't been incorporated, is irrelevant for its domestic purposes. So a state can find itself torn, I guess, between what it's taken on internationally and what its domestic courts might be deciding, which is why, to me, as an international lawyer, I think certainly taking international law into account seems a sensible approach in terms of interpreting the laws of a country to look at its international obligations as part of that context, as you say, Michael, seems to me a very reasonable way to go about it.
That might be so, but the answer came back, well, it might be reasonable, but states are often hypocrites, and they will sign on to treaties to get any praise or domestic support for doing so. But the fact that they don't then implement it is something which is just too bad for the person who wants to rely on it. And that was the answer that was given. Not at Bangalore. At Bangalore, the judges seemed to be, most of them, by the way, had international principles of human rights incorporated in post-independence constitutions. And therefore, they would look primarily to their domestic Bill of Rights. But Australia and the United States, relevantly, don't have the same kinds of rights, and therefore they either have to expand such rights as they have in their constitution, or if they wish to, and if they think it's lawful, to look outside the text of the law and to ask, is this something, when the country has gone to the trouble of ratifying a treaty, or even perhaps signing the treaty, that the judges can look to as a contextual matter for the purpose of clarifying what the domestic law is. And basically that was the key that Justice Brennan found in Mabo against Queensland at 175 Commonwealth Law Reports 1 at 42. I have it there in my mind. That was the key that gave Justice Brennan the power and the duty to give expression to the common law as elaborated and influenced by international legal principles in relation to race. That's what he said. The one matter upon which international law speaks with clarity and unanimity is that you cannot impose upon people a subordinate legal position by reference to their race. And that is what was the key that opened the door of Mabo. And many people attacked Mabo at the time, but I think nowadays most people would accept that Mabo was a timely invocation of international law to aid us in Australia to a better solution to the rights of the First Nations people.
And Imogen, if I can just chime in there for a moment, of course, the Australian government has long had a policy of only ratifying or entering into treaty obligations when domestic law is consistent with or will be brought into consistency with international law. And that works imperfectly, but it does work, at least to some extent. What I've been noticing is, and I might say more about it later, what I've been noticing is an increasing acceptance by Australian courts, particularly the High Court, that it is very important to, wherever possible, ensure international consistency of interpretation of obligations that arise under international law, but that have been given domestic effect. And so I am seeing the courts now being fully aware of their role as an international actor within the domestic legal system.
May I say also that the lawmaker in our society, in our system of law, is not just the Parliament. Judges have a lawmaking responsibility, particularly when you get to the Courts of Appeal or the High Court. They have a sort of obligation to update the common law and to re-express the common law, and the right of judges and their duty in some circumstances to re-express the old common law is not something that most people now deny. Most people accept that that is part of the judicial function. And Professor Julia Stone, who was a considerable international law scholar, said that that is a feature of the common law, that judges have leeways for choice. That was I think he borrowed Radbrook's expression, leeways for choice. And from the leeways for choice in the ambiguities of text, they have the right and sometimes the duty to re-express the old law and to take into account the international legal principles that have evolved.
And I guess, looking at the role of judges, but also, Chris, that concept you brought up of international legal consistency, that's why we're seeing reference not just to judgments of international courts, such as the International Court of Justice, but also to other foreign courts. Because
there's a clear shift towards what I'll call the sort of cross-fertilisation of principle between superior courts. And superior courts undoubtedly are in dialogue with each other, aware, I think, of the fact that consistency of international interpretation matters, and paying, not deference, but at least respect to the views of each other's opinions. And we saw that particularly in some of the litigation that's involving Spain, which has taken place both in this country, but also in the United Kingdom, Canada, and the USA.
So we've been talking about treaties, we've been talking about customary international law, and what we've been talking about, when we talk about influence, we're usually talking about looking at international law influence existing domestic law. But we also have the instance when Australia enters into a treaty, they will then usually enact legislation to bring effect to that treaty domestically. And as you said, Chris, Australia's practice is to not enter a treaty until it either has that legislation in place or has plans to bring it into place. But Michael, I wanted to ask you a question about this, because when we talk about these international crimes, for example, war crimes or crimes against humanity, these have been incorporated into Australian domestic criminal law because in line with our obligations under the Rome Statute to the International Criminal Court. Now, Michael, you've written about the implications for Australia when ratifying treaties because of the growing impact on international law on Australian law. Would you like to unpack this a little for us?
I hear what Christopher says about the policy of Australia. And it's true that there used to be such a policy, and it was a policy that was basically favoured and obeyed under successive governments. But in more recent years, also under successive governments, you've got a bit of an inclination to say that even if it is part of a treaty which Australia has ratified, that's something that can go into the never. And there was a case in the High Court in my time which concerned the right of a person who was a prisoner to have the opportunity to make an oral submission to the High Court. And we, under the arrangements for video links, could have made a provision for prisoners to have a right of an oral submission. However, the court, at least during my time, stuck to the principle that only with an advocate, a barrister appearing, they could have an oral submission. And the court itself would apply to local bar associations if it thought the matter was arguable and try to get assistance. And often the bar associations around Australia would cooperate. But sometimes they didn't, and sometimes the prisoner wanted to have the opportunity of 20 minutes to advocate in the days when special leave applications were overwhelmingly accompanied by an oral submission. And that issue, that was denied, and the High Court stuck to the old principle only with the aid of a barrister. And the matter was taken to the the Human Rights Committee of the ICCPR, and they said Australia was in breach of the treaty here, and the discrimination made the breach even more clear because of the fact that we were allowing other people with money in their pockets who were not in prison to make their submissions, but not to prisoners. So that was the subject of a communication to the ICCPR. It found Australia in breach, but that breach was not fixed up. And so I'm a bit questioning about the notion that Australia, lily-white, never ratifies a treaty unless in the very near future it will enact a law to bring that treaty into operation. And if that has broken down, and if that is not being done, then a premise upon which the common law had adopted, or international customary law had adopted, the kind of principle that was said to be part of Australian law, that has really been undermined. And that's another reason why I think courts should be willing, in appropriate cases, to look to the international law and find whether in that international law are germs of ideas that can be used to accommodate and change Australian law.
I absolutely agree with you, Michael. And maybe before we return to that idea of the influence of international customary law, I just want to stay on this idea of instances where states and Australia does actually enact domestic legislation based on a treaty. And I wanted to ask you, Chris, as a legal practitioner, do you find that there are differences if you're preparing for a case that is based on legislation that incorporates treaty obligations, as opposed to a case that is based on legislation that is purely domestically based?
Yeah, definitely. Although the distinction is perhaps sliding a little bit because of the way courts are now expressing the presumption of consistency of interpretation, the presumption that legislation should be interpreted in a manner consistent with Australia's international obligations. And so the old distinction is possibly not quite as stark as it used to be. But to take the most straightforward example, in a case in which the question is one of interpretation of a statute that directly gives effect to international law, or at least by necessary implication does so, the starting point is to consider both the domestic statutory context and purpose, but also the international meaning of the underlying treaty provisional rule of international law. And we've known from at least 1997 and the reasons of Justice McHugh, notwithstanding his views in Al-Kateb, but the reasons of Justice McHugh in Applicant A and Minister for Immigration, that the interpretation of a treaty provision for the purposes of Australian law involves the application of Vienna Convention on the Law of Treaties rules. Those rules will apply whether or not the treaty in question postdates or predates the Vienna Convention, because our courts have also accepted that the Vienna Convention codifies rules of custom. And so you immediately turn to the international meaning for the purposes of international law, and that involves looking at the text of the treaty and its object and purpose and the travaux of the treaty, of course. And just to give you two examples, that happened in Wells Fargo Trust Company against VB Leaseco, which was a Cape Town Convention case arising out of the collapse of Virgin Airlines. And similarly in Kingdom of Spain, where a lot of international material in those cases is put before the court. And so the answer to your original question is, yes, in cases in which we are giving domestic effect to an international treaty, we're doing essentially the work that you would do before an international tribunal to build up the international meaning of the treaty and place that material before the court. Now, there's some very interesting questions that are slightly unresolved at the moment about the manner in which you prove international law before domestic courts, and whether there are questions of proof of foreign law or whether you can simply tender evidence. And the Federal Court of Australia is deeply engaged in that question at the moment in cases such as Euro and the Commonwealth. So there's still some things to be worked through, but the opportunity to put the material before the court is clear, and that's the way we approach these cases these days.
I was interested to hear Chris referring to Justice McHugh and his approach to this. And I'm having lunch with Justice McHugh this very day. We're going to celebrate Sir Anthony Mason's most distinguished career because we used to have lunch with him. And I'll have to remind him of his inconsistency on this issue because although in Al-Kateb he declared that I was being heretical by referring to international law, in Mabo against Queensland, he agreed with Chief Justice Mason, and they agreed with Brennan, with Justice Brennan. And you could not get a better, clearer statement of the Bangalore Principle than appears in that passage in Mabo against Queensland number 2. And I think I was so unkind as to mention that in my decision, my reasons for decision in Al-Kateb against Godwin. That is always worth reading. And my associate at that time was Sarah Nucky. She's now a professor at Columbia University in the United States. And she still talks about the exchange of Justice McHugh's reasons, his amendment to his reasons, my amendment to my reasons, his amendment to that, and ultimately it was just settled, and Justice McHugh declared I was heretical, and I declared I was not, and in any case he had himself agreed to this in Mabo number 2.
I'd better not express a decided view on this, given some of the cases I work in, but it's certainly true to say that one of the great uncertainties left in this field is the application of international law and its principles to questions of constitutional interpretation as opposed to statutory interpretation. But I'll just leave that hanging for the future.
Well, I just want to mention, when you mentioned Sarah Nucky, Michael, Sarah and I were on the UWA 2003 Jessup team together.
She was a wonderful associate, or clerk as they call it in the United States, and I've given a lecture to her class on these issues, and she was really buoyed up, and she said it was a very fascinating week to be an associate, that all these opinions were coming in and denunciation by one justice of another, and I'll raise a glass with Justice McHugh today to Al-Kateb and what we severally said. I'm sure that my view of taking into account as a contextual matter international law will have to be accepted. And so I don't think this is going to be engraved on my heart. I think it will be established doctrine by the time I go to my reward, which will be a long way from now.
Let's hope, definitely.
Absolutely. Chris, I do want to come back to the Bangalore Principles, Michael, but before I do that, I just wanted to follow up with you, Chris, in terms of what you were saying about when you do prepare for something based on legislation, there's an explicit route in for international law. But I was thinking about it when you talk about the international criminal law and, with the context of this podcast being international crimes that are now being tried in domestic courts. I guess what that means is that domestic criminal prosecutors might need to expand their knowledge of international criminal law in a way that they perhaps haven't had to, because, for example, the charge of crimes against humanity, this is the first time it's ever been brought in an Australian domestic court. So it's going to be an interesting time, perhaps, for federal prosecutors or state prosecutors.
Yeah, I think that's right, and certainly, we saw that in Crown against Tang, which was one of the early slavery cases a few years ago. These are international crimes that have been explicitly placed into domestic legislation, and the principles are now well established, but the content and the underlying international legal meaning is going to have to be worked through, and most of the provisions are reasonably well understood at international level, although obviously there's a lot of ambiguity in some fields, and that's why the International Criminal Court and various ad hoc tribunals still grapple with these questions. And it is the case that domestic courts in this country dealing with international crimes not only have an impact in domestic law, but potentially feed into that international judicial system as well, because decisions of national courts will find their way into the subsequent cases before international tribunals in the ICC. And so, yes, that process of dialogue is going to require domestic prosecutors to become aware of the underlying principles.
But not just prosecutors, but in many ways it'll be more relevant to the defence.
Yes.
To have regard to what the international law says that is protected of fundamental human rights, given that we don't have such things in our constitution.
And I think that point of ambiguity is a really interesting one, because, of course, when we're talking about the international instruments, they're negotiated instruments. They're treaties that have been the byproduct of negotiations of a large number of states. And so sometimes those ambiguities might be deliberate at the international level to allow the maximum number of states to participate. And it's different than the domestic process where, yes, legislation is negotiated, but it's negotiated in a party system where there can be more control over specifics of the legislation.
And we have seen, some of these cases arise in migration and refugee application settings where there are specific exclusions to various visa categories for people who have been found to have committed war crimes. And I've been involved in one or two of those cases, but the courts have grappled with the content of war crimes and facts that may or may not amount to war crimes in particular foreign contexts. And so it's not as though this is something that's never happened before, but it does involve deep engagement with the principles.
Michael, just returning to the Bangalore Principles, which we've been talking about throughout the podcast, one, to me, striking thing about the Bangalore Principles is it was a call not just for consulting international treaty law, but consulting international law in general, including international customary law. Why do you think this is important, that we look to international law more generally rather than just the treaties that a country might have specifically entered into?
Well, international law, it's a matter of conceptualizing how we're going to deal with international law, given that it has come along. It's been around for centuries, but it has certainly grown since the Charter of the United Nations, and it's an active component in our lives as lawyers today. And most of the judges who were there in Bangalore were insistent that this was not controversial in their countries because of the fact that they dealt with it all the time. But Australia and the United States, as Justice Ginsburg emphasised, have had this very exclusionist dualist view, and it's been a very insistent view. And in fairness, some judges say, well, that's because we are a democracy and we are entitled to have matters passed upon by the democratic parliament. But we all know that a lot of things don't get passed upon for the precise reason that you've mentioned, Imogen. They're controlled by parties. Parties want to win government. They don't want to upset constituents in outlying suburbs of the major cities, and therefore they don't necessarily follow through on their internationally accepted obligations. But the judiciary has its own lawmaking process, and the judiciary has its own obligations to consider the municipal law in the context of international law, because they are both sources of law. And originally, the Bangalore Principles said that it was only if municipal law was ambiguous, But later examinations of the Bangalore Principles have suggested that that was an unnecessary requirement, that ambiguity in the municipal law was not necessary to open the door that allows municipal law to be seen. And as one New Zealand case, I think it was, said, it would be a limitation on governments going off and ratifying treaties that they never intended to implement, and then saying, well, too bad, it's not part of our law. I suspect that that was the position that had been reached in that case of the prisoner who insisted on his right to oral submissions. It's Muir against the Queen, and it's a reported decision. It had to be given extempore immediately in the special leave applications, but it was given, and it's in the ALJR, and it's a pretty good decision on the part of Justice Kirby, even if I say so myself. It convinced the ICCPR.
We will link to it in the show notes, so anyone listening can go and read the decision. Chris, I have a question for you about something that is thankfully in our past, but our recent past. One example of international law impacting Australia domestically was the COVID-19 pandemic.
Okay. Yep.
Now, you've written an article assessing the international consequences of the pandemic, including World Health Organization law. I was wondering if you could just talk a bit about how international law intersects with Australian law, how it did in that context or does still.
Yeah, that's a really interesting question. The pandemic was obviously unexpected, although the World Health Organization had procedures in place designed to deal with it. And so did, for example, ICAO in the context of aviation and International Maritime Organization. So there were procedures in place designed to respond to pandemics. But I think the implementation of those procedures was imperfect and has given a lot of food for thought moving forward. What we found really was a deep tension between the desire of domestic governments, both state and Commonwealth in Australia, to isolate and insulate Australia, and our international obligations to continue to allow measured air traffic, which ultimately didn't happen, but ICAO's rules were probably honoured more in the breach than in practice. But just focusing on cruise ships, for example, which with the Ruby Princess, of course, became a very hot topic. We have to allow, under international law, rights of innocent passage. We have to allow ships that are exercising rights of innocent passage the ability to anchor and interrupt that passage in cases of emergency, and particularly in the case of health crisis. And then we have to, as contracting state to a number of treaties, we have to offer assistance to ships and passengers in distress. And so we had those sorts of obligations on the one hand, competing with the overwhelming desire of Commonwealth and state governments to restrict entry. And the way that played out in practice was, I think, something which we will continue to learn from moving forwards. And the way that the rules of UNCLOS, Convention on the Law of the Sea, operated with the Navigation Act, for example, are again things that we will have to work through. One of the interesting examples was the case of, you might recall, and your listeners might recall, at one stage in the height of the pandemic, the Commonwealth Government banned the return of any traveller from India to Australia. And I was counsel for a number of a sort of representative action for a number of Australians who were stuck in India as a result of that ban. The feature of the ban wasn't that it banned people from India travelling to Australia. It was that it didn't distinguish between citizens and non-citizens. And the particular legislation did permit biosecurity declarations to be made that on one interpretation permitted temporary restrictions to be put in place. And the federal court did make a finding that a right of return was a fundamental attribute of citizenship. That is, all citizens have a right to return to Australia, which can't be abrogated other than by clear words. That's an application of the principle of legality. And, of course, the finding that citizens have that right of return has implications for current events, but I won't say anything else about that case at the moment. Ultimately, the Federal Court found at first instance that the words of this particular act were sufficiently clear to abrogate the right on a temporary basis, and then before the appeal could be launched in a significant way, the ban was lifted. So it's a very interesting case. It's called Newman and the Minister, if anyone's interested, and I'll give you a link, Imogen. It's a very interesting case about both fundamental rights of citizens and principles of nationality, but also the principle of legality and how international law might feed into the abrogation of fundamental common law rights.
It can't be an accident that some of the most virulent resistance to the idea of the Bangalore Principles arises in countries which are islands. That is to say, Australia, which has got sea around it and can stop people entering it, and the United Kingdom and New Zealand and Japan, for that matter, they do tend to be, to coin a phrase, insular. And I think there's a lot of insular thinking in Australia that is surprising to people beyond Australia, and to some extent we've got to get over it. Anyway, I'll be saying that to Justice McHugh over lunch and a glass of wine today.
I think that's a really good point, Michael. And I guess what struck me, Chris, during the pandemic was, for a lot of people, it was the first time issues of borders and migration affected them personally. You know, as Australians, we come from an island state, we travel, we hear about refugees, but unless we've been from that background, it never affects us. The idea of not being allowed into a country. We're very lucky we have a passport that allows us to travel unrestricted to a lot of places. And COVID was really the first time, I think, the idea of international exclusion and borders and international law hit home for a lot of people who hadn't been affected by it before.
I think that's very right. It was a shock to the domestic system and domestic personality as much as anything else.
I have one final legal question for you both before I turn to our final question. So my final legal question is, thinking about international law and domestic law, is there any rule or set of norms of international law that you would like to see incorporated more in Australian domestic law than it is currently? And why would that be?
Well, I'd like to see the ICCPR incorporated. I mean, when you read it, I was given the Universal Declaration as a small boy in a public school in Sydney, Australia. And my teacher, who had fought in the war that was then just concluded, said, you boys have got to read this and understand it, because it's going to be important for the survival of our country and of the world. And he was not a person who glorified war. He hated war. He'd fought and seen death and destruction. And unfortunately, that's become even more important in recent times. In terms of the WHO, for example, the United States departure from that, from the World Health Organization, provides an example of how many problems today are international problems, and they need an international solution, and courts have to play a part in finding those solutions. And so that's why I've never lost confidence that this evolution of our law will occur, and it is occurring. And the fact that you, Imogen, have been able to mention 3 cases at the beginning of this podcast, which are before or shortly will be before the High Court, is an indication that the modern judge has to have familiarity with international law and has to think about it and think about how it is to relate to our domestic legal system. It's a reason why international law is so important and is growing in importance, and the attempt of others to prevent it being heard is not going to succeed.
Imogen, I don't disagree with what Michael says about the ICCPR in particular. I mean, we have bills of rights or charters of human rights in various states and territories. The world isn't falling in with the domestic implementation of of rules of international human rights law in that respect. I mean, clearly international law in some respects is moving ahead of domestic law. I'm thinking particularly of perhaps climate change and juvenile justice and rights of young people not to be imprisoned at a young age as two areas in that context. I do think, though, it is important, given our constitutional processes and structures, that the domestic legal system maintains respect for those constitutional and parliamentary processes of our democracy. We are, in many respects, still a dualist system, and it is good that the judiciary has a deeper engagement today with international law than in previous years, and there are many things we can learn from international law, but international law remains something that isn't automatically part of our domestic law. And so whilst there are parts of international law that I would probably like to see come into our domestic system, it has to be done, I think, with some care and appropriate debate.
I agree with Christopher on this. And the one thing you learn from a life in the judiciary is things are messy. They are not always totally logical, and they proceed in a messy way. But if we look at this topic, we can see that this is a change that is in the process of happening, and it will take time and there will be different approaches, but the money is on the future of the Bangalore Principles. And that's why every lawyer watching this or listening to this podcast has to buy Christopher's new book with my wonderful new foreword to the book. And I'm not saying that we have a total unanimity in our views, but it is an issue whose time has come.
I absolutely agree. I guarantee you I'll be buying a copy of the book and then getting you to sign it, Chris, and hopefully you as well, Michael. I do have one final question for you both. It's taking you outside the world of law. And our question is one we ask all our guests this season. What is your current escape route? What are you reading or doing or viewing that takes your mind off law, if indeed your mind is ever off law?
Well, in my case, my mind isn't very often off law because I'm still involved in international commercial arbitrations, and they are very complicated, and that's a sort of full-time job. But if I want to escape, I've got a very good friend who sends me every Sunday J.S. Bach's a cantata for the holy day of that week. And, it's amazing that Bach had such ability to make magnificent music, and it often had a religious function and a spiritual function. And so my answer to the question is music, music, music.
Imogen, you perceptively say it's difficult to escape. I like your terminology of escape. It's difficult to escape at the moment, international law, and I'm pretty absorbed at the moment in the task of ensuring that international law responds deeply and actively to the attacks that are being made upon it as a system by, I'll just say, certain world leaders who might prefer autocratic displays of military force to respect for the rule of law. And so I am working with a number of international institutions to try and ensure that international law prevails. But beyond that, when I do get time to escape, I'm spending time with family and riding my wonderful thoroughbred horse, Rory, over the countryside outside Canberra. And I might even sometimes be found showing passengers a different view of Canberra from above Canberra in a light aircraft. So there's always ways to escape.
Escaping the earth, quite literally, in your case.
Exactly.
Michael Kirby and Christopher Ward, thank you both so much for coming. It's been an absolute honour to have you both and a delight to discuss these issues. And that concludes our episode.
Thank you, Imogen. Thanks, Michael.
Thank you.